Welcome to Property Power Talks, the exclusive podcast for NB Property Law. I'm your host, Kayleigh Swift, and each episode will dive into cutting-edge insights on property law, probate, estate planning strategies, and seamless estate administration. Whether you're a property investor, homeowner, industry professional, planning your estate, or wanting to understand how estate administrations work, then our expert discussions will empower you with the knowledge you need to navigate the complexities of property and estate planning law with confidence. Let's unlock the power of property and estate planning law together. Hi, thank you for joining us here on the Property Power podcast. I've got today's guest with us is Lauren Robinson, Property Management Consultant. So a little bit about myself, Kayleigh, here at NB Property Law. So I'm one of the directors here at NB Property Law. We're part of a law firm with 4 divisions. So we've got the property law and we cover off on estate planning. We've got a commercial law division, NB employment law, and our final division is the migration law division. So what we're all about here at NB Property Law is offering our clients a personalised, proactive advice to minimise their risks and take the stress out of their next property transaction or estate planning matter. We're more than just a team of legal experts. We're dedicated problem solvers committed to creating personalised solutions to guide you forward from residential to commercial property law concerns, and we're here to provide the clarity and guidance you need. I'll pass over to Lauren to introduce herself.
Thanks, Kayleigh. It's a pleasure to be here. I've been working in property management for 22 years. And I owned an office which I ran for nearly 8 years. Since then, and since 2018, I've actually been doing property management consulting as well. So working with agents and fellow business owners to develop marketing strategies and create a trusted brand to help supercharge their growth in the property management area. So yeah, lovely to be here today.
Awesome. Thank you very much for that, Lauren. So what we're going to cover off on today is we're going to go through the key reforms, which some of them commenced on the 24th of June 2023. We'll be speaking about the rent bidding ban and other relevant changes that have happened in that space. We're going to talk about the changes that have actually impacted upon purchase and sales contracts. We'll talk about the further changes that come into effect on the 30th of September this year, and we'll go through what the break lease fee caps and extended notice entry periods are. We'll be speaking about what penalties we'll be applying for the breaches of all these new changes and what practical implications are going to be in place now for landlords. We're going to go through operationally the leases and the fee adjustments and what rights the Queensland Civil and Administrative Tribunal will now have. We're going to speak about the tenants' rights if the new billing and entry laws are not complied with, and the strategic compliance and communication. And then we'll finish off with some legal tips for understanding all this new legislation. So to start off with, we're going to pass over to Lauren to speak about the overview of the actual key reforms in Queensland's rental market.
Okay. Thanks very much, Kayleigh. So we've had quite a lot of changes. So from the 6th of June 2024, we had a couple of key reforms around annual caps on rent increases, notice periods remaining at 2 months, and applies to both fixed term and periodic tenancies. So we have a ban on rent bidding. So we're no longer, if a tenant, for example, a property is advertised at $500 a week and tenants come in and offer $520, we're no longer allowed to accept that. So it makes it a lot fairer. People know, or tenants out there who are applying for properties know that that's the rent that's being asked. We've got a maximum rent in advance. So no longer can a tenant come in and offer, say, 3 months rent in advance. That can't be accepted. So the maximum amount that can be accepted is 1 month's rent in advance. And then rent increases are limited to every 12 months. So this actually applies to the property. So if you have a 6-month tenancy, you can't increase the rent after 6 months. The rent has to be at the same amount for the 12 months. And that these lease agreements moving forward actually have a clause where you have to enter the last rent increase. Exemptions for rent increases, there can be an exemption for it's exempt from. There are a couple of exemptions in there, and you just need to have a look at where it sits in the Act, and evidence of the last increase, which we mentioned as well. Undue hardship, so a managing party may apply to Queensland Civil and Administration Tribunal, so QCAT, for permission to increase the rent within 12 months due to undue hardship. So if, for example, an owner decides to renovate the property, and obviously normally a rent increase would be able to be the rent would be able to be put up. You can't, because there's a 12-month stop on that. And then fixed price, so rooming accommodation must be advertised at a fixed price.
Thank you very much for that, Lauren. So I'll speak a little bit now about the actual Residential Tenancies and Rooming Accommodation Act 2008, which is a Queensland piece of legislation. So this act doesn't actually apply to all tenancy arrangements. So the ones that it's excluded from is if there's a tenancy created from the sale of a property and the tenancy is for a period of 28 days or less. So often, the buyer may agree to lease back the property to the seller for that period of time. Also won't apply if there's between parties to a mortgage under the terms of that mortgage. Other ones that are exempt is if the occupancy is for a holiday purposes. Now, our right to occupy for 6 weeks or longer is not considered holiday purposes. If the occupancy is for a rent to buy agreement as well. And lastly, for some longer term leases will be exempt under that legislation. So we'll go through now and talk about the actual rent bidding ban. So now we'll speak a bit about the other relevant changes that have come into place in terms of the compliance and enforcement for penalty breaches, and also go through the education and awareness under the government initiatives for increasing awareness. So we're going to go through now and talk about the education and awareness that the actual Residential Tenancies Authority is providing to educate property managers and also tenants and landlords. I'll hand over to Lauren for that one.
Thanks, Kayleigh. So the REIQ and the RTA both have a lot of education and awareness around these new changes. There are also other private training companies that are doing a lot of training on this. But if you jump onto the RTA Queensland website and put in new legislation, there's a number of videos around, and short videos around what the changes are, what's occurring, and there's continual training occurring with the REIQ as well on all of these changes that have been rolled out. So we haven't had a lot of changes in the industry for a long time, and now all of a sudden we've had significant changes occurring, in the last 12 months.
Awesome. Thank you very much for that, Lauren. So with all these changes that are coming in with the new tenancy laws, we've also seen changes to the residential purchase contracts in Queensland. So as part of the contracts, generally they're an REIQ contract, or we do sometimes see what's called an ADL form. We probably see about 85% of contracts used are the REIQ one, and the remainder are generally ADL form. There are some special ones, but they're the main two that are used. So with those contracts, they've now been updated so that a seller must now disclose to a buyer if the property has been subject to a residential tenancy agreement or rooming accommodation agreement at any time during the 12 months prior to the contract date. So if the property has been rented out at any time during this 12 months leading up to the contract date, the seller must provide details of when the actual last rent increase was and what amount that was. So at settlement now, sellers must provide to the buyers a copy of any tenancy agreements that are in place, a notice to each tenant advising of the sale, any notice to transfer to the buyer their interest in the bond, evidence of the last day of the last rent increase for the property, and a copy of previous rental tenancy agreement, a written notice of the rent increase, and a copy of the actual rental ledger as well. So this now forms part of what is an essential term under the residential purchase contracts, which means that if the seller fails to provide any of this information on or before settlement, they will be in breach of the contract and the buyer can terminate the contract if need be. So we'll pass over to Lauren again now to go through what the new minimum housing standards are in Queensland.
Okay. So when buying a property, it's important to make sure that the property meets the minimum housing standards. And this also applies to property management. So, for example, this includes being in good repair, including fixtures and fittings, not being likely to cause any injury through normal use, being free from vermin, damp and mould, making sure that there's curtains or window coverings which provide privacy in rooms where the tenant might reasonably expect it, such as bathrooms, bedrooms, where there's privacy required, and has functioning locks or latches on all external doors and windows that can be reached without a ladder.
Wonderful.
So when we're looking at the changes that occurred from the 30th of September. So there's been a number of changes that have occurred. So probably the most significant is around the reletting cost. So previously the tenant would be responsible for all reletting costs. So they would be responsible for any fees that the agency would charge, but also responsible to pay the rent up until the day before a new tenancy commenced. Now that's changed. So the reletting costs are calculated on the remaining time on the tenancy or the rooming agreement, and whether the fixed term agreement is greater or less than 3 years. So for agreements up to 3 years, it's the lower amount of the specified renting costs or the rent until a new tenant resident moves in. So if a property is leased in 5 days, then that's typically what the tenant would be responsible to pay, 5 days rent. So that's a significant change and can be costly for landlords. Rent payments is another one. So tenants must be offered 2 ways to pay the rent, including a way that does not incur more than the usual bank costs and is reasonably available to a tenant. And then utility costs. So if you're passing on the charges for water usage, for example, these need to be passed on within a 4-week time frame. Otherwise, the tenant won't need to pay that. So there are also changes to how the water charges are calculated and can be charged when a tenancy begins or ends during a billing period. Other changes are in regards to the rental bond processes, so the maximum bond. So no more than 4 weeks rent can be requested by a managing party. There may be a provision in certain circumstances for tenants to request a refund of bonds paid over the maximum amount prior to these changes occurring, because we used to be able to charge tenants for extra bond if the rent was over $700 a week. And then there's evidence for bond claims. So when you're making a bond claim or disputing a bond, the property manager or owner must provide the tenant with supporting evidence within 14 days of lodging a claim or dispute. So for bonds lodged with the RTA before the 30th September 2024, there's a 12-month transitional period from the 30th September 2024 to the 30th September 2025, which applies. So that allows property managers to prepare for the change, but it is best practice to be providing evidence when there is a bond claim. Also in regards to legislations and enforcement, so there's information sharing. So the RTA has the ability to share information with other government agencies and departments to drive greater compliance and enforcement outcomes for the sector. And providing false or misleading information is an offence for anyone involved in a tenancy to provide false or misleading information to the RTA.
Wonderful. So many changes there, so thanks for explaining them in detail, Lauren. So we'll speak about now what are the actual penalties then for breaching a lot of these new laws that have come into place. So if you are a landlord and you do fail to comply with the requirements of the Rooming, Tenancies and Accommodation Act, you could be facing financial penalties. So currently the financial penalty value per unit is $161.30, which is current as of the 1st July 2024. So if you are advertising or otherwise offer a premises for rent without a fixed amount stated, then the maximum penalty can be up to 50 penalty units, which would equate to $8,065. If you're engaging in rent bidding, the maximum penalty is 50 penalty units, so the same amount. It's up to you to ensure that a residential tenancy agreement is in writing and you can only collect the authorised amount. So a residential tenancy agreement must include the standard terms, any special conditions, and the date of the last increase. And authorised amounts can only be the key deposit, a holding deposit, a rental bond, and the actual rent. So failure to comply with providing the residential tenancy agreement, including the authorised amounts, could result in a maximum penalty of 20 units, which would be $3,226 currently. In addition, a tenant can also apply to the Queensland Civil and Administrative Tribunal, and the tribunal can make one or more of the following orders. So, one being that the lessor or the lessor's agent pay an amount to the actual tenant, that the agreement actually has no effect, an order varying the terms of the residential tenancy agreement, or any other order that QCAT considers as appropriate. So we'll go through now what are the actual practical implications for landlords in terms of bond management and capped bond amounts. I'll pass over to Lauren for that one.
Yeah, I guess when it comes to capped bond amount, so previously the reasons why a landlord would want extra bond would be that if the property had a significant value, or perhaps there was some risk involved. So maybe there was a large pet that the owners were unsure about. So there were ways to alleviate that risk. So I think it comes back to having really good landlord insurance in place, making sure the entry condition reports are really thorough, routine inspections are kept up to date. If there is evidence of any damage at the routine inspections, making sure that breach notices are issued, and just thinking about the end or the worst case scenario, and making sure all your T's are crossed and your I's are dotted. So, but yeah, having all those things in place is really important. In terms of the bond management, so making sure when you're claiming for bonds that you've got lots of evidence. So having your exit condition report, your photos in place, making sure you get quotes, and it needs to be like the tradesperson ideally needs to have visited the property to quote accurately around any damage. So it is just trying to make that process more streamlined and more transparent for both the tenants and the landlords as well. But so I guess having those things in place.
Awesome. Thank you, Lauren, for taking us through those practical implications for the landlords. So we'll now go through QCAT and what their role is. So as I mentioned before, QCAT stands for Queensland Civil and Administrative Tribunal. They have the right to hear residential tenancies disputes. However, if your dispute is non-urgent, you must first go through the Residential Tenancies Authority dispute resolution process. So some examples of what is considered as a non-urgent dispute would be disputes to deal with rental bonds, any disputes regarding pets in rental properties, the minimum housing standards, disputes arising due to termination due to serious breach, or any disputes that deal with routine repair orders is what would have to first go through the Residential Tenancies Authority dispute resolution process. So as part of these new laws, QCAT now also have some new rights that they've got in place. So if your dispute is urgent, then you can apply directly to QCAT to be heard the matter. So ending a tenancy agreement for reasons could include such as any repeated breaches that have taken place by the landlord, any excessive hardship that the tenant may be suffering, if there has been any property damage to the rental premises, if there is a warrant or possession that has been undertaken, if there are emergency repairs that need to be done, due to, roofs caving in from flooding or different things like that. And lastly, the other one is any domestic violence issues that arise would be considered an urgent reason to end a tenancy, and therefore we could apply to QCAT directly. That can be done by the tenant. So I'll hand back over to Lauren now to talk about what the lease fee and adjustments are and how that is impacting everyone.
Yeah, so when it comes to break leases or leases ending prior to the end of the fixed term tenancy, it definitely has impacted. That's probably been the biggest impact for landlords. So tenants, I guess it's something to factor in, that if a tenant does give notice during their tenancy that they're going to be breaking their lease, and it's just being aware that there likely will be reletting costs that the owner will now be responsible to pay, probably advertising fees, and so unfortunately they're things that won't now be covered by the tenant, which used to be. So it's having a financial buffer in that, and I feel like that may actually impact the rents in the end, because as a landlord, if you this is a business. It's going to be affecting rents will ultimately increase in the end to cover these sorts of things, because when the owner at the end of the financial year is looking at their statement and they perhaps are not getting the same amount that they did, previously, that will end up impacting the rents in the end, unfortunately.
Wonderful. Thanks for giving us that insight there, Lauren. So we're going to speak now about what can a landlord actually legally do to end a fixed term lease earlier than the stated termination date under the lease. So there's a few ways that a fixed term lease can be ended early. The first one is the parties. So the tenant and landlord must mutually agree to end the lease early, and this should be in writing so that we've got evidence of this. Secondly, if the tenant has actually failed to remedy a breach within the specified time frame for that breach notice, then again the landlord can also end that lease. Next, if the tenant's actually abandoned the property, then that is reason for the landlord to terminate that lease early. If the property is wholly or partially destroyed and becomes unlivable, for example, after a natural disaster, whether that be fire or flood or something like that. And lastly, a landlord can end the fixed term lease early is if QCAT actually orders the end of that agreement due to various different reasons that we went through before. So there's a few different ways that the landlord there has the right to end that lease early. So some ways to end the fixed term lease early as well by the tenant, so this is on the tenant side, would be if the owner has failed to remedy a breach within the specified time frame as well. If a co-tenant has actually died and the remaining tenant wants to end the agreement early, then they have the right to do so. If it's within the first 7 days of occupying the property and it does not meet the minimum housing standards, the tenant can also end that fixed lease term early. Or lastly, if the property is wholly or partially destroyed and becomes unlivable through natural disaster, as we mentioned before, the tenant and landlord therefore has the same right in that regard. How do we go then about ending an actual periodic tenancy? So fixed term tenancy is, a lease for a fixed period of time, whereas a periodic tenancy doesn't actually have an end date. It's just a periodic time that the lease just keeps continuing on for. So to end a periodic tenancy, if the seller has entered into a sale contract and the buyer requires vacant possession, then the property cannot be let after the property for rent for 6 months after handover date of the tenancy. Another way is if the owner wishes to move into the property. So the property cannot be let or offer the property for rent for 6 months, though, after the handover date of that tenancy. We can also end a periodic tenancy agreement if the owner plans to actually demolish or redevelop that property. And lastly, if the owner wishes to either renovate or do significant repairs to that property, is the last way that we could end a periodic tenancy early. So I'll hand back to Lauren now to talk us through what the operational adjustments are that have come into place.
Thanks, Kayleigh. So when it comes to operational adjustments, with the water and utility bills, I would be suggesting that all water and utility bills, or that where the tenants are responsible to reimburse the owner, come directly to the office, so that the office can then invoice the tenants for usage like within that same week, or at the bare minimum within that first 4 weeks. Otherwise, if you have owners who receive bills directly where the tenant's responsible to reimburse them, making sure that they're aware of this new legislation and the importance of sending those to the office straight away so that you could then invoice the tenants for usage. And adjusting, so there will be new legislation coming out in May 2025, which is around entry notice periods, extensions and things like that, where it's just making sure that you're adjusting everything to come into line with the new changes. So that would be sort of the best way to do that, and making sure the team are aware of all of the changes as well.
Wonderful. Thanks very much for that, Lauren. So in terms of the rights of tenants, if new billing and entry notices laws are not adhered to, what are the implications then for the landlord? So basically, if landlords are failing to comply with these new requirements, then they will be responsible or up to a maximum of 40 penalty units, which currently is $6,452 they may have to pay. Additionally, after the 1st of May 2025, when Lauren mentioned these new laws will come into place, the property manager or owners must disclose any financial incentives that are being received. If they fail to do that as well, they could be in breach and likely may have a maximum penalty of up to 20 penalty units payable, which is $3,226 currently. Lastly, any impact of the failure to provide correct notices is unchanged, but you must ensure correct notice period is provided at all times. So I'll hand back to Lauren now.
So when we're looking at strategic communication and compliance, it's really important to make sure our landlords are really well informed of all of the new changes that are occurring and making sure that there's steps in place that, for example, the utility bills, if the owners are paying those, that they're aware of the impact of not receiving those in a timely manner could have, in that the tenants may not be responsible to reimburse them, but also just making sure that everyone is aware, so tenants, landlords, and obviously the property management team are all aware of the new changes and start to make some changes within the office to adhere to these new changes.
Wonderful. So obviously quite a few new changes that have come into place. So in terms of the process for these future laws and how they're applying, so the changes are obviously being rolled out in stages. So the Residential Tenancies and Rooming Accommodations and Other Legislation Amendment Act in Queensland for 2024 was passed in Parliament on the 23rd of May 2024. So some of these laws received royal assent on the 6th of June 2024, which meant that's when they come into play. The next lot, stage 2 of these laws, come into play on the 30th of September 2024. And then the last stage of these new tenancy laws have a proclamation date, which means a start date of the 1st of May 2025. So there's also a grace period that has been provided for certain sections of these new laws. One of these is that if a person is buying a property between the 6th of June 2024 and the 5th of June 2025, and they have not been provided with details of the rent increase information, then a seller will be exempt from having to provide this to a tenant due to the changes, only coming into play shortly before the contract being signed. So we'll now pass back to Lauren to sum up any final comments you'd like to make regarding these new changes.
I guess just some of the things to be aware of that are coming out in May 2005 is in relation, Kayleigh mentioned earlier about the disclosing benefits. So if an agent's receiving any financial benefits in regards to the rent payments, that must actually be disclosed. Entry notice periods, that's changing. The minimum notice period is currently 24 hours. It's increasing to 48 hours. Entry frequencies, so there's going to be new limits applying to the frequency of entry after a notice to end the tenancy has been issued. Protecting privacy, so there's new limits applying to the personal information that can be requested and collected by managing agents. There's actually going to be a standardised rental application form which will be created and must be used when a tenant is applying for a rental property. So that's going to be used across the board. And then requests for fixtures and structural changes. So there's going to be revised processes for a tenant to request fixtures and structural changes to the managing party, who must respond within 28 days. So more changes to come, but from the 1st of May 2025.
Wonderful. Thank you so much for that, Lauren. There's so many changes that have come into place already, in June, the next lot that come in play in September, and obviously more to come in May. So there's a lot to get your head around, whether you're a property manager, a tenant or a landlord, with all these changes to the laws, but it is important that we're aware of them. So I appreciate your time today and taking us through some of those changes. Thank you for listening. If you do have any questions, obviously you can reach out to Lauren Robinson, Property Management Consultant, or myself, Kayleigh Swift from NB Property Law. Appreciate your time. Have a great day. Thank you. Thank you for tuning in to another episode of Property Power Talks. We hope you found today's insights valuable and engaging. If you enjoyed the show, don't forget to subscribe and leave us a review. For more information or to connect with our expert team at NB Property Law, then please visit our website at noborderslawgroup.com.au. We look forward to having you join us next time for more expert advice and actionable strategies to master the world of property law. Until then, stay informed and stay empowered.